Good morning, everyone, and hopefully you've had a good last night in Kőszeg and are ready and willing and able to start with today's discussion. And today you will get a rather large dose of law, so don't be scared. For those of you who are not with a background in law, we'll try to make it interesting for non-lawyers as well. My name is Áron Fábián. I'm a research fellow here at iASK, and it is my distinct pleasure to chair this panel with two great colleagues and friends of mine. Csaba Győry from Eötvös Loránd University Faculty of Law Center for the Theory of Law and Society in Budapest, and Márton Matyasovszky, also from Eötvös Loránd University and Bibó István College in Budapest, and also a research fellow at iASK. So without further ado, I want to jump into today's topic. For this discussion in the morning, we've planned on discussing issues related to human rights, the rule of law, and how they are intertwined, as well as how do these standards, which we like to think as universal and rather unbreakable, are actually broken, and how might we design systems that better enforce them and enable us to actually live up to the values embodied therein. So that's my very brief introduction. We'll try to make it interactive for you, so feel free to participate in the discussion, and there's also going to be time, hopefully, at the end for some questions and Q&A. So I will now give the floor to Oh yeah, originally we would have had another panelist from Bosnia and Herzegovina, Damir Banovic, who was unfortunately unable to attend at the last minute. So we've had to expand the scope of the panel, and Márton was kind enough to jump in with some prepared remarks, and instead of just helping me chair this panel. So hopefully you will get something coherent out of this. So now I give the floor to Csaba.
Thank you very much. Is it switched on? Okay. So thank you very much. My name is Csaba Győry. As Áron said, I work at the Department of Legal Theory, or its fancy name, Center for the Theory of Law and Society. And there I mostly work in the legal theory field on the theory of rule of law. But that's maybe 25 or 30%, and the rest of my work, especially my empirical research, is on corporate crime, financial crimes, financial regulations in a very global context. So when I was invited to this panel, I was thinking about what I could contribute to a panel, because I don't consider myself a human rights lawyer. I actually worked for 3 years for a human rights organization as a human rights lawyer, mostly policy issues in Brussels. Long time ago, but I've never been a practicing human rights lawyer, and not familiar with the case law, so I would not want to claim to be one. But there is an aspect of international human rights law which I am interested in because of my interest in corporate crime, and that is business and human rights. And this is what I would like to talk about today here with you. The main topic I would like to discuss here, to sum it up in one sentence, is there hope for public international law, or are we doomed? To be more precise, what the problems that I would like to talk here about is that there are all sort of mechanisms in public international law that helps large corporations to evade liability for human rights violations. This is due to recent developments in public international law, but also a lot of structural factors in public international law. So before we get into these questions, we have to start a bit further away, elaborate a bit more on the challenges. And number one, obviously, to kind of hark back a little bit to the theory of rule of law. Why is rule of law important? And that kind of bifurcates then later as we talk about the questions that I just outlined. that why do we rule of law? Obviously, rule of law means, on the one hand, that private actors comply with legal obligations, including corporations, including human rights obligations. On the other hand, rule of law also means that the legal environment is predictable and you can plan long term. And a state which is, that's the problem that we are going to discuss, is it's one party of these investment treaties and investment contract with states and between states and corporations. The state obviously can change its own laws, so one party can change the legal framework, and it's also a human rights, a rule of law problem in itself. And there are various challenges. I would like to go briefly into all of them. And number one is what we call fragmentation in legal theory, the fragmentation of public international law, and as I call it, old and new, because there is a structural characteristics of public international law that makes it inevitably fragmented. And there are new developments in this fragmentation, which is the most important of development there is this kind of the growing importance of sort of legal systems or quasi-legal systems that are questionable whether they are laws at all, because they are neither national laws nor public international law, but just work as law. And as we debate legal theory, which we also teach in our legal theory lecture, whether these systems, legal systems or norm systems could be considered law or not. And there you obviously have the selective compliance by corporations, but also by states, which obviously weakens enforcement. And there is one particular issue which I will emphasize, we will discuss at great length later, is international arbitration, where national legal judgments of national courts could be overruled. I will explain this later, what this means. But let's start with the sort of old fragmentation. So public international law is not a unified body of law. There are different legal regimes. There is trade law, there is environmental law, there is human rights law, there is investment law, and all of these have their own enforcement mechanisms. Some more robust, some essentially non-existent, or not so robust, and obligations arising from these different legal regimes can conflict with each other. There are a couple of cases which I will explain later. Just one example, which I will explain in a moment in greater detail. Philip Morris versus Uruguay. Uruguay changed is national health laws and introduced a smoking ban. Was the first country that introduced a pretty strict anti-smoking policy back in 2005 or 6. And Philip Morris sued Uruguay for infringement of investment in the country, and has became a case. And I'm going to discuss that case a bit later. So let's moving on to the sort of a new kind of fragmentation. And I have to make a note here. Most of you are not lawyers. That is not everything new in this. The Lex Mercatoria, which is the law of merchants, is an old medieval system of transnational commercial law. You know that back then, national states didn't exist the way they do exist today. There were like very fragmented legal regimes all over the place, overlapping with each other, conflicting with each other. And was in order to foster international trade, international commerce, there was needed something that was universal or transnational. And this is Lex Mercatoria responded to this, rooted in Roman law in late medieval times, and became very important in helping, developing international trade in Europe. But it has a kind of renaissance, if you will, in the 20th century, where it returned in the terms of a legal norm system that is applied in international arbitration between states and companies. And the problem with this is they're still not, codified in national law or in public international. It's just there. and states bind themselves to apply it to the disputes arising out of contracts they have with corporations about investment in those states. And that kind of gives it a validity, but this is not a law that is created. It's just organically developed through decisions by these arbitration tribunals. It's also not an established precedent system. If you just read these judgments, so it develops like that. And it is disputed by the law at all, because it, based on a lot of legal theoretical approaches, it doesn't qualify as law. It doesn't have legal validity, but it just works as law. People apply it, people enforce it. So does that make this norm system a law? This is a question for a different presentation, but I would just flag that it is disputed. And this is, as I said, it's frequently invoked in sort of state investor disputes, and sort of overrides national law like that. And the reason what this conflict showcases is there is a fundamental conflict of interest between corporations and states. But it, again, as I said, rule of law theory bifurcates here, because both corporations and states have legitimate interest. States obviously have legitimate interest to shape their policies as they seem fit, as the democratic legitimacy behind policy changes, and it belongs to the very nature of democracy that policies change from time to time, because majorities change and governments change, and they change the policy. This is what democracy is about, and they should have the right to do that. And especially weaker states oftentimes get are forced to accept these treaties between corporations and states that due to debates, to any sort of disputes between them, this international lex migratoria applies, and that puts these states at disadvantage. But on the other hand, corporations also have a legitimate interest, because it's a rare case of a contract where one party of the contract can change the law governing the contract, and if one party is a state, they can do that. So corporations need this kind of long-term stability too, and it's a legitimate interest for them to do. But what comes out of this dilemma and the kind of institutional solutions that develop this dilemma, that states oftentimes, especially states from the global south, are put at the great disadvantage in their discussion, in their disputes with powerful multinational corporations, and it's much stronger and much more robust enforcement mechanism as human rights law or environmental law. And these kind of lex migratoria and these treaties between states and corporations almost inevitably prefer sort of long-term stability, which also kind of binds democratic decision-making or autonomy of a democratic polity. And I brought you two examples, and I want to ask you then whether you think whether are any difference between them. So number one is Philip Morris versus Uruguay. That was between the Court of Arbitration under the investment dispute between states and that's not the official name. It's a long, boring name. I just paraphrase it. Philip Morris introduced, Uruguay introduced a very strong anti-smoking policy. It was one of the countries with the highest rate of proportion of smoking population. It was a huge health crisis for the country. Obviously, it's not a rich country, and this kind of health risk is not just for states. It's not just being nice to its own people. It actually, if people are not in a good shape, that costs a lot of money for the state. So it's the case of legitimate interest to reduce the cost of healthcare that is spending on people. So it's a very strong anti-smoking ban. It didn't ban smoking, obviously. They banned smoking in a lot of places, introduced a new tax on tobacco, or raised the tax on tobacco, and also introduced this, one of the first countries in the world, introduced this system where you have these pictures or warnings on a tobacco, what they call in English, the boxes, packages, yeah. And Philip Morris also claimed that its IP rights, its trademark rights are infringed because people couldn't see the camel on the camel. So that hurt the economic interest. And also they claimed there were legitimate expectations based on the treaty between Philip Morris and Uruguay. They have that the legislation doesn't change dramatically, so it provides them with a sort of predictable regulatory environment. And the tribunal actually ruled in favor of Uruguay, as a rare case when it happens. It essentially said that ensuring public health is a fundamental prerogative of any democratic state, in the police powers, in the parlance of this trade and investment law. And it doesn't, also noted it didn't ban smoking, just made it, banned it to certain places. And also elaborated that the stability of regulatory environment that doesn't extend to preventing legislative changes in line with changing policy priorities from the government. So there is because in law usually called regulatory means like the administrative law. And that environment, it can make business very costly if that environment changes constantly, there are additional costs, and companies have a legitimate interest not to have that change non-stop, like it is done in Hungary, for example. But as a different thing, where you say, I change my policy on smoking now, that's not just this kind of administrative change, there's a big legislative change, a policy change, which the Uruguayan state or the polity has a right to do. As another one is Vattenfall was Germany. Vattenfall is a big Swedish energy giant, and they had two nuclear power plants in Germany, both on the Elbe River north of Hamburg in Krümmel and Brunsbüttel, and one of them was quite famous because this Krümmel, because a lot of incidents happening there. So there was already a debate ongoing in Hamburg whether we need that and it's too close to the city and so on and so forth. And as you know, in Germany you have the Green Party, which always advocating from the early 80s from leaving nuclear energy altogether. And it was part of a very substantial part of the German energy mix, and the CDU, the big conservative party, was against it. But then after the Fukushima event in Japan, they kind of made a U-turn on it and agreed with the Greens and the Social Democrats that Germany would quit using nuclear energy by 2022. It actually happened 2023, and Vattenfall, who own these nuclear power plants, actually sued the German state on a different arbitration, details doesn't matter, and claimed that it infringed in its long term on its property rights, because they usually planned that these nuclear power plants will operate for X number of decades, and they just cut it half for cut 70% of that. Do you think there is a difference between these two cases? Or the strength of the cases of the corporations? Or you think it's the same?
It's an open question.
It's an open question, yeah. What do you think? Yep.
I think there's a difference actually. That the second case there's the property thing, which actually in the first case there's it's not there.
Mm-hmm. Yeah, but states can just pay David's advocate here. The states can also sort of limit the usage of your property rights. in the public interest. Do you think that applies here? I have no clue. Okay. Okay. Yeah. Yeah.
So I
see difference because one of them is a proven health hazard, other is ideology with unproven health hazard.
Okay. Says the astrophysicist. Yeah. Yeah.
Anyone else? Maybe.
Feel free.
Yeah.
Yeah.
Yeah. Go on.
Be fun sometimes.
I mean, I don't know all of the concepts and everything, but it reminds me a little bit on this theory in the United States where they advocated that universities have certain public functions. And here it may be related with the fact that nuclear power plant, despite the fact that it is, you know, privately owned, it does provide some essential functions to the, you know, electric network or whatever. So this may influence it.
Yeah.
Anyone else? Maybe want to jump in?
What do we get for the right answer?
Counter argument. Yeah. So because this kind of goes into the core of the problem I'm talking about, because I personally believe that is a bit different because you know, building a nuclear power plant costs enormous amount of money, and it's a long-term investment, and it just you should have that expectation that it operates for a long time. I think that's actually a legitimate claim. I think there's a conflicting claim from the state that it can say, you know, it is, you know, as democratic policy has decided that it will quit nuclear, that will cost them more money. They had to invest in alternative energy sources, make energy more expensive. The grid will be a bit more. You have to import energy from abroad, and so there's lots of risk associated with it, quitting nuclear energy. But they want to take all those risks. It's up to them, and you can also argue that there are hazards associated with it, as we see it in Fukushima, as we see it elsewhere else, to the public health, to the state budget, and there are public health and public interest reasons against this private right. Yeah. 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 Yeah, but it's ideology. But states, if you have a majority for that ideology, then it's democratic policy. That's how it is, huh? And this case was settled to Germany because there was a parallel case in front of the German Constitutional Court, and the German Constitutional Court ruled. There's two rulings. One of them said that with a different German companies also sued the state for that, the operating power plants, and the number one ruling said that it's not unconstitutional to decide that they will change the energy mix, but they have to make a proper compensation because it's an infringement on property rights. And that was the Vattenfall case, and the German settled the arbitration case too and paid 1.6 billion euros, of which 1.4 was cash. So what I brought this up because, as you could see in the discussion here, I think that also shows that companies have legitimate interest to have this kind of long-term stability, and it often clashes with decisions of democratic polity or changes in policies. And there's not strictly legal, but there is one more element to these disputes which I want to talk about, is that there are also international financial institutions that finance the big infrastructure projects, especially in the global south. They also pretty I would say devil may care attitude to legal rulings. in those countries. In two cases, the Belo Horizonte, Belo Monte Dam in Brazil, which was a gigantic dam on the Xingu River in Brazil, which would provide enormous amounts of electricity to Brazil. It's a growing economy, but it would flood indigenous land and enormous amounts of land, and also enormous, a gigantic territory of pristine rainforest, to which indigenous communities have a claim to. And there was an internal conflict within Brazil too, a political conflict, a legal conflict inside Brazil, but also outside Brazil. But Inter-American Court of Human Rights ordered the project to halt because of the infringement of indigenous rights. But Brazil just ignored the rulings and continued and actually threatened to leave the International Court of Human Rights. At the time, and the World Bank has no issues with all these things. Another one is Lake Turkana Wind Power Project in Kenya. Lake Turkana is in the north east of Kenya. It's a desert lake, and it's for geographical and climatic features are such that a very strong wind blowing is obviously almost constantly there. And Kenya wanted to build a gigantic wind turbine station there, but also it's on land that was indigenous land, and they seized this, changed the law, seized this land, and there was a dispute within Kenya, and then the Kenyan High Court ruled as a long protracted. It's a very complicated case, but it just to summarize it briefly, the Kenyan court ruled that they had to settle their claim, settle their issues with the indigenous population locally. That the state just ignored the rulings and just continued building the project, which is now operational, and is still not settled. Again, World Bank had no issues with it. You actually quit the project later, but because they think it's too large, and it would generate too much electricity without the proper grids that would be able to transport it to other countries or to other parts of Kenya. But again, World Bank had no issues with local courts ruling against a project or halting the investment. So there are these tendencies that you kind of either you go to these arbitration tribunals if local courts rule against you, or just disregard the local courts, especially if those local courts are countries from a global south. But I want to make a note here again, just to kind of balance this view with, because it is not actually just the global north that disregards court rulings when it's against its interest. You have it in other countries too. I put up a couple of examples. We always have the cases with the powerful states and the corporations. Russia or United States or Philippines versus China is a claim on certain islands in the South China Sea. The Permanent Court of Arbitration ruled against China, or just simply disregarded it. But the global South states also disregard international law when they see its interest. So I would like to make it look like that they are the good guys and not the bad guys. These countries also disregard rulings. The al-Bashir case, you probably heard about it. He was the president of Sudan. He was indicted by the International Court of Criminal Law at the ICC, International Criminal Court, for the genocide in Darfur, and he traveled to South Africa was a participating state. He traveled to South Africa to a summit, and the government refused to arrest him, even though its own courts ruled that it has to. And as you have a same story with President Putin, who was also charged and has an arrest warrant outstanding against him. I think they will look at conflicts like that when now with the big detente, he starts to travel. But I could hear cases from Africa, Tanzania, Rwanda, both of which withdrew from the African Court of Human Rights, and you have cases from Latin America too. So that just a mental note here that it is happening elsewhere. So state sovereignty is still has this traditional conflict that doesn't just apply to the global north. And how do states, just to move on a bit with the argument, how do states avoid accountability? One I already mentioned, arbitration, which overturns national court rulings. A good example is Ecuador versus Chevron. Ecuador, Chevron, Texaco, and later became Chevron, had a long project in Ecuador, and it dumped enormous amounts of toxic chemicals into this pristine rainforest. And there was a case it's also a complicated case, the details doesn't matter, I can talk about it if you have a question about it, because there was a case in the United States, there was a case then it was moved to Ecuador, and an Ecuador Supreme Court ruled against Chevron, and Chevron so had a legal obligation to pay under Ecuadorian law, but they went to the arbitration tribunal and nullified the claim of the ruling of the Ecuador Supreme Court. And even in cases where it works, like the Philip Morris case, you can argue we lawyers like to use this term, the chilling effect. These arbitration proceedings are very expensive for states too, and arbitration, these kind of, if the legal disputes are very costly to the states. So even if they ultimately win at the end, they can have cheating effect whether you want to flex their muscles against companies. Another problem is asset relocation. That just in a globalized economy, it's not a difficult thing to move assets around. And because that's what Chevron did, for example, and moved all of its assets out of Ecuador to evade enforcement. And you also have forum shopping, where delay cases to try to move it to countries or jurisdictions when they expect favorable judgment, either when the case is ongoing or even already setting up the whole operation like that some other jurisdiction legal disputes are fought out in other jurisdiction. There also are successful cases here. So again, I want to make it as not as dark as it initially might have sounded. There are cases here. A couple of them are on the slides where companies succeeded to enforce a judgment, local judgment against companies. To move on a bit, what are the solutions, the potential solutions to these problems? It's not the first time we obviously talk about it. There's a lot of scholarly activity going on, a lot of NGO activity going on it, but also IGO, intergovernmental organization activity going on it. So as to the first problem, that all these tribunals favor corporations over states because of the language of this whole body of law and nature of these treaties or contracts. The solution is what is floated by European Union is the multilateral investment court. They would put up, because these courts are arbitration courts, which works very differently from non-lawyers who think a court works. Because you think a court is a big building, you have judges in robes, they pay their salaries, and if you have a legal dispute, you go to them, and they have kind of someone has jurisdiction, some court has jurisdiction. These courts, these arbitration courts don't work like that. These courts basically have a list of people who could be judges in arbitration or arbitrators, and each party select one, and these two judges then elect the third. So the treaty itself, or the contract itself, creates the court that is going to adjudicate the disputes arising out of the contractual dispute. So it's one of the arguments. It's actually not a real enforcement mechanism, because it's just sort of there is no law. The contract creates the court itself, or the contracts create the law itself. or it's a contract without a law, or the French expression, to use the French expression. And this EU proposal to multilateral investment court would change that and turn this into a proper court, a proper permanent court, where is an appeals procedure, where are judges, where are clear procedural laws that applies to everybody, and there are some sort of basic norms that includes human rights that this permanent court then would apply. It's not yet operational. EU has been including this in its trade deals in 2015, but faces opposition from other countries like the United States and others. So it's not working. It's not working yet. Another problem is, as I mentioned, is that cooperation evade liability for human rights abuses. And the solution to this is that you have a binding treaty that on business and human rights, and there is a long process that's going on for a long time now, various drafts and within the United Nations, and is supported by Global South but opposed by the EU and the United States. And even if you look at the proposals that exist today, they're not proposing a formal court system. It's more like strengthening enforcement within national law or sort of extrajudicial settlement mechanism. So alternative dispute settlement mechanism is the proposal. Third, relocating assets is that, some sort of having set up some sort of global asset tracing and seizure agreement. This is also nowhere yet, apart from people talking about you need one. That's where we stand now. To elaborate a bit on that, one way of going about it is that we would somehow reform or overhaul index for state dispute settlement in a way globally where human rights standards couldn't be overruled or domestic law couldn't be overruled. You can also strengthen enforcement mechanism, for example, and I will talk about in a moment, to put compliance to incentives, for example. And the EU is trying to do that, but the EU is also very selective in doing that. To connect trade benefits with requests for some sort of respect for basic human rights or enforcement of basic human rights standards. You could also expand regional courts jurisdiction and capacity to enforce rulings against corporations, rulings of tribunals, but also international courts. Or again, it having this sort of global asset freeze regulation or system where you can kind of freeze assets globally. There's a lot of problems with this too. I will talk about it in a moment, because all of them have potential pitfalls. Strengthening enforcement mechanism with human rights standards and might backfire, either because powerful states would just simply withdraw from such agreements, or that this could also be selectively enforced. And the EU is actually doing that already. The EU is very generous with Saudi Arabia on the same violations that is very strict on with Venezuela, for example. So this doesn't prevent selective enforcement if you incorporate this into trade agreements, human rights standards in trade agreements. If you would reform this investment law in a way that domestic courts will have some sort of final say over them, that would basically eradicate the system as such. And that would make investment, probably would chill investment in a lot of countries, and countries need that investment, especially global south, in the global south. So it is also has its own dangers. If you expand regional coast jurisdiction, that creates legitimacy crisis. As you can see, you have African states withdrawing from the African Court of Human Rights. And as you look in the UK and elsewhere, you see a very strong populist backlash against international courts, whatever that it may, overruling national judgments. And that can further kind of antagonize states and international courts. So it's a delicate balance that you have to find, especially if there is just one human rights treaty that you have to withdraw from. And withdrawing from the European Union because you don't want to have a Luxembourg court telling you what to do, that's a bit more complicated than just saying, okay, from now on we are not part of the African Convention on Human Rights. And if there would be a closer national international legal cooperation, that could also further erode a national sovereignty, again bringing this sort of populist backlash. And asset freezing can also be weaponized. Also can be selectively enforced by powerful states when it benefits them, and not enforcing when it doesn't benefit them, because they have the economic might to enforce this. And that kind of leads me to the final question. As I said at the beginning, is there hope? Here. Is the enforcement of the rule of law in this international arena? We have sovereign states with hard power, military power, economic power, but also powerful corporations, without the capital of which countries in a global south could develop, or the investment couldn't develop, because the state is not rich enough to build whatever big investment, infrastructure or investment you can do. Obviously, you can say that there are successful examples of that. For example, enforcing sanctions against Russia. But the question is, does it work if it doesn't work together, but it works to some extent? Does it work, or if we would really start working the multilateral investment court here? Will it work because the EU has good arguments, or is acting ethically, or it works because of the brute force economic power of the European Union, which is the largest investment importer and exporter of foreign direct capital on the globe? So what makes it work, if it works? Is it because the EU is just one of the largest economies on the planet? Does it link with the United States and China? Or does it work because we have a good and ethical arguments for this court? If we create, on second problem, if we create another layer of enforcement, a layer of jurisdiction, then, and it's always a problem when you propose new courts to settle disputes between courts, because in 15 years or 10 years you will be sitting in Kőszeg and discussing what to do with the conflicts between these new courts and the old courts. So there will inevitably be jurisdictional disputes, no matter how high you go. You are inviting a new level of disputes, or jurisdictional disputes between these courts. So where we will end up with this is that there will be in a world where powerful states can enforce public international law because of their hard power when they seem fit. And we just hope that they're getting better or more ethical. EU is trying to be more ethical than the US is. But it's still, we make a lot of compromise on that. So we're still acting in our interest when we seem that fit. So that's the final question, essentially, I would put to you, that if the enforcement mechanism rests on sheer brute power, economic power, or military power, economic leverage, like asset freezes, sanctions, trade restrictions, exclusion from trade benefits or exclusion from markets, does that mean that the rule of law still rules? Or is it something that the maximum we can have and say that it preserves the rule of law for now, relatively or to some extent, and then but is centrality of power of economic and military power won't change. So that's the question I want to finish on.
Thank you so much, Csaba. Now we've, after days of discussing rather high-minded ideas, we've brought in the lawyers and discussed the nitty-gritty. That was my feeling of it. But now I give the floor to Márton, who will talk more about the human side of things, and hopefully will leave us in a more high-minded mood. And afterwards, I do hope we will have some time for questions. Yeah.
Is it okay, Gergő? Okay. Yeah. Okay. It's always weird to have this tele-evangelical role here. So hello everybody. I'm Márton Matyasovszky-Németh. As you've heard, I work here as a researcher in iASK and a senior lecturer at ELTE. And as my research focuses on, or my research would focus if my interest always would work, focuses on the meta theory of human rights. I'll explain what it is. So the theory of human rights and the methodology of research of human rights. And I mainly focus on the sociological and anthropological research of the practice of human rights. So my question in my research is that how do we study the practice of human rights? How do we get knowledge on the humane and societal side of human rights? And when we heard the sad news that Professor Banovic got the flu, I became a bit I got a bit panic attack because Professor Banovic is a renowned scholar. He would talk a lot for you about human rights in Bosnia-Herzegovina, which is I wouldn't say fun, but which is radiant and thought-provoking. And I know Csaba for a long time. I really like his research. Business and human rights are always sexy. It's also sexy for business major students at our university. Although I think economists hate law at all, but okay. And I had the idea that I teach a course for a postgrad course for already graduated and practicing lawyers at our university on an LLM course which called Human Rights Masters of Laws. And I teach there the sociology and anthropology of human rights. And when I write down this title and I present it to them, it's already upset. The title is already upsetting for them. Last year, I created, and I really liked it, high tense debates among my students because they looked at the PPT and asked me, human rights, social facts, what the heck? Because I asked them that, how do we study the practice of human rights? And they answered, it's obvious, black letter law and case law. So the statutory law the more boring part, and the case law. And there you have an understanding of how human rights work in practice. And I was like, okay, that's one side, that's the internal side, that's the lawyer side of human rights. But how do you know if an old farmer in, for example, rural Vas megye thinks anything about human rights? Is there any knowledge of human rights? Is there any culture of human rights in local communities? And they are like, we never thought about that. That's interesting. And for the first course, for the first lesson, for me, it was fighting with them. I tried to persuade them that the human side is important. And we have to think about that if we are lawyers, even if we cannot put in to practice our feelings, because it would hurt the rule of law. But we have to think about that if we want to be good lawyers. It's my credo. You can challenge that. And when I brought you this topic, I was like, okay. I challenged practicing lawyers. They got upset because of the title. And now I'm going to speak to a crowd where mostly non-lawyers are present. Social scientists, philosophers, natural scientists, historians, who are aware of these axioms, what I'm talking about, that rights are cultural facts, are historical facts, are social facts. So how do I challenge you? And I was like, okay, let's try. I'm gonna ask you the questions I give to my lawyer students. So please answer, and we can continue. I think it's more fun to start like this. So my first question is that what are human rights, and what are human rights for? And I'd like to get answers. There are no wrong answers. I have 3+1 question for you from the starting. So I please the show master.
Pass the microphone to anyone who wants to
get into action. So what are human rights, and what are they for? No wrong answers. Human rights are for humans. So
I have a question and comments. So according to UN system, human rights are basically rights everyone endowed, and it helps us to achieve a common basic minimum ways of living with dignity. Now, whom it serve? That's an interesting question. So, coming from the global South, and proponent of epistemology of the South, I believe who is calling from where? We just need to look at the Human Rights Security Council, who is calling the shots. So, also, when it comes to the big corporates, as you can see, it's always those with a lot of money, with military power, West. When it comes by the end of the day, they call the shots. But let's not forget that in some society, like authoritarian society or society which is full of dictators, human right could be the only language to challenge the oppressive regime. Maybe North Korea, China, India, Global South, some societies. But human rights also at some level has seen as a moral imperialism, abstract notion. And that's why there has been a lot of skeptical views in Latin America and Global South about human rights. So it's a double-edged sword. For me as a human rights researcher, I love it, but I know I may sound as an elite to the Global South people actually, because they see as a foreign discourse, enemy of the state, which impinges on the sovereignty of the state actually. So it's very problematic, but still at least we have something to proud of. Common humanity. But human word in itself was problem. But there was a time was human word was related to the white people. And other people, women, children, foreigner were cockroaches. So we shall not forget the origin, but we shall also appreciate the relevancy, the current time. Thank you.
May I respond? Just a quick,
Yeah,
just a quick respond. Will you be in Bratislava next autumn? This autumn. Okay. We will change emails, and I'll invite you to my course during the fall for one of my lessons, if it's okay for you, because you just outlined what I wanted to say. So
Sit down then.
No, please don't. A human rights scholar got the micro first, but I want to hear others. So universalism and cultural relativism, this is one of the first problem. It includes the question of the so-called epistemology of the global south. It comes from the renowned scholar called William Twining from the UK and Abdullahi An-Naim from Sudan, who resides in Emory University currently. And you also raised the core philosophical question of the justification theory of human rights. Is it moral or is it political? So that is what my PPT is going to be about. But please, what are human rights and what are human rights for? There are no bad questions, no wrong answers, no wrong questions if you have questions.
I'm confused. Who's human right? Yeah, I'm holding this. We are entitled to use this microphone. Somebody died in a hellhole to get the cobalt for it. So my human rights, can it infringe on other people's basic life? So locality and globality is very important.
Thank you, Professor Marka. Thank you, Professor Marka. Yeah, that's a question. Professor Marka paraphrased the problem what we call human rights researcher called the core list of human rights and the proliferation of human rights. So what are the most important human rights? Those which are included in the UDHR or in the American Constitution or in some of our national constitutions? Or we can proliferate human rights into an extreme level, like do I have a human right to a microphone? I hope not. Sometimes it's important to me to be slightly.
We have an online question.
Yeah, we have an online question and we have a comment there. Please, Maria.
Yeah.
Yes, can you hear me?
Yeah, properly.
Can you hear me?
Yeah, properly.
Yeah. Hello from Skopje. Yeah, I'm sorry for not being there, and I'm really hoping that you're having a great time. I have a question for the first speaker, and it's regarding the ISDS, the Investment State Dispute Settlement. Considering that I'm making my PhD on CETA, and I'm really interested about your opinion about the transformation of CETA from Investor State Dispute Settlement to investment court system. Do you think that this achieved the balance according to the position from the public views? Because the first based investment state dispute settlement caused a lot of protests in Europe, and it was in the same time with TTIP. And I'm really interested about your approach to protection of investment on the one side. Do you think that this kind of dispute settlement mechanism is protecting the corporation or investors? And it's not on the good side, like protecting the labor rights, environmental standards, etc. Like one of the main reasons why the states in comprehensive economic trade agreement between the European Union and Canada didn't ratify the agreement till now. Thank you.
At the end, I think, Maria, if you don't mind, we'll wrap up with Márton's questions and whatnot and get back to you later, okay? Perfect. Okay, and we had a...
So, I am Erisa from Public Health Institute from Albania. I'm a researcher at Public Health Promotion. And when we are talking about human rights, the first thing came at my mind is the freedom to eat healthy something, to drink water, to have the right to education, to have the right as a woman in science, and the freedom of my speech, to say something, to think. I think this is the basic human rights, and to live somewhere under the roof with basic things. I think this is the first thing it's the strongest human rights for every person in the world.
Thank you very much. I really appreciate this answer because this is a list which I think these are utterly important human rights. But if you ask a lawyer, a basic, well-trained lawyer, they will say, okay, but who will enforce it? How do you enforce it? So, for example, my head of department back at ELTE thinks that second and third generation human rights, so social and economic and cultural rights and group rights are non-existent because there is no way to enforce them in practice. So thank you. There's a commentator there.
Good morning. Thank you very much. I am Satish from Sri Lanka, or PhD from ELTE. From my knowledge, human rights, it's a knowledge, nothing else. And it's for marginalized people, exclusively for elites. Thank you.
Thank you very much. Thank you. Is there anybody else, please? If not, would you present my presentation? Thank you. But I will have other questions. So your answers showed which I think the core question of human rights. And it is that human rights are for human, and it is very important to do research not only on the law of human rights, but on the culture of human rights, because it tells a lot about the actual practice of the law of human rights, and it can help to reform and to enhance the practice of human rights. Okay, thank you, and be please as active as you were now. Okay, so there are in the classical thinking of human rights, there are two schools of human rights theories. One is the moral, and one is the political side. The moral side, the so-called moral or orthodox approach, derives from the existence of human rights from a higher moral value. It is based on the theoretical paradigm that human rights are natural rights, that all human beings are due by virtue of their very human existence. So what it is a thinking which was argumented by the first commentator, my colleague from Coimbra in Slovakia, who started his answer with that human rights are for safeguarding human dignity. And the other side is the political theory, which says that the representatives say that we have to build our theory and catalog of human rights from practical ends linked to the justification of political actions, and they argue that human rights play a crucial role in international politics. For you, because you are not lawyers or human rights theorists, these approaches are not antagonistic at all. I hope so. but these approaches were considered as antagonistic to each other for decades. And in the past 2 decades, there, thank God, there's a vibrant debate between moral and political justification theorists, and there's an emergence of new theoretical work which combines the 2 earlier positions and acknowledge the moral and political legal characteristics of human rights. But I think it is very important to approach human rights and human rights theory from a different perspective, this holistic methodology, and we have to take into account the result of the sociology of, and anthropology of human rights. Okay. Okay. So my next question is, what do you think when human rights were born? What is the historical event or point where you which you would find as a starting point for human rights?
As far as human is assist, I think human rights start at least from one point. So there are contradiction is over the evolving of human rights, but at least some reasonable concessions, I would say the 1948, the Universal Declaration of Human Rights, at least the recognition of a universality of human rights, or even going beyond, or even the pretext of human rights, I think the Magna Carta could be one of the instrumentals. Thank you.
Okay. So 1948, UDHR, Eleanor Roosevelt. One possible answer. Other answers? Starting. Yeah, the historian. I hoped. I really had hope that some of our colleagues. So. Our historian colleagues, I'm just repeating it for the online audience, say that the starting point of human rights is the French Revolution. One other answer. Bill of Rights, English Bill of Rights, so 1689. Yeah. Our colleague from Georgia. I'm just repeating it for okay. Other dates, yeah.
One of the finding, it goes back to Hammurabi Sahinta code. There was some code in Syria, actually I don't know exactly, but it was coded by Hammurabi. Goes back that period. What could be also.
Thank you. So from very ancient times. Other ideas, There's no right answer for that. It was a nasty question from me, but I was very interested in your answers, because there's an ongoing debate in the last decade, which was started by the Harvard legal historian Samuel Moyn, who examined the history of human rights and argues that human rights, as we now understand it, only became alive in the late 70s. Until then, we understood, if we paraphrased the rights of man or human rights as human rights, we understood utterly different concept on human rights. Moyn was very lucky, because everybody hated or loved him. So now he has one of the biggest citation index in Harvard Law School. he said that human rights became the last utopia, and once I will cite it because it's very important. Once it acknowledged that that there were and are could be many universalism, the fact that one or another movement or culture is universalistic lends it no necessary role in the prehistory of human rights. The rights of man were about the whole people incorporated itself in a state, not a few foreign peoples criticizing another state for its wrongdoings. Revolutionary era rights, so rights of man, the concept of rights of man from the French and American Revolution, was the justification for the creation or renovation of a citizenship space, so and not the protection of humanity. Because when human rights entered the English language in the 40s, it was unceremoniously, even accidentally, and the concept never did percolate in public and around the world with anything like the currency it acquired later. Moyne thinks that the very first year of modern human rights was 1977, and I thought because the great Jimmy Carter died some weeks ago, we can spend some time with his inaugural address. So Moyne thinks that the year of human rights was 1977, and it started with the inauguration of Jimmy Carter, who put human rights in front of the viewing public for the first time in American history. That was the year when Amnesty International received the Nobel Peace Prize, and Moyne argues that January 20, 1977 was the date when human rights became a publicly acknowledged buzzword, and this is the year, this is the date when the story of modern human rights starts. I think all of you are right, including Moyne. There are many histories of human rights. There are many faces of human rights. There are many cultures of human rights. But it is very important to keep in mind what Moyne says with his deconstructualizing work, that we have to be careful with these saint cows, and we have to research on their history to know what we mean on, for example, human rights. Okay. So what are human rights? I tend to agree with Lawrence M. Friedman, another legal historian from the US, but he comes from the West Coast. So East Coast first and now West Coast. So Friedman thinks that human rights are just massive social facts, because he believes that both human rights movements and human rights theories should be seen as massive social facts that are crucially and historically contingent. And we have to, I don't think that we can, we have to observe differences in human rights practice between different social groups. And I think it's very important what he says, because he seeks to explore the sociological dimension of human rights, as a result of which he explains that it is not a list or catalog of fundamental human rights that he seeks to outline, but rather to explain and discuss how human rights as social facts fit into contemporary society. It's very important. Fitting into contemporary society became a vocabulary for the civil society, or the global civil society. It is very important to study where they come from and why they have such a powerful legitimacy, or why they don't have such a powerful legitimacy for those who invoke them. Okay. I will leave this. Today, in the eye of modern social science, human rights are social facts. I think this is not a question for now, but it's still a question that can we claim that human rights are universal, or can we not? The first speaker, the first colleague who answered my first question, highlighted this debate because many things that Western influence of the discourse of human rights, on the global discourse of human rights, is about accepting and presupposing the Western concept of universalism without condition. And these thinkers are doubtful about the normative nature of human rights because they argue whether it can be truly universal or not, or can we pose any theoretical challenges to this West-centered theoretical challenge? Yeah. So there's a new obstacle to universal human rights theory, and that's why we have to highlight the question of cultural relativism. This argument raises the question of how groups from different cultures outside of the West, so it is the epistemology of Global South debate, adopt individual legal discourses derived from a moral system different from their own. So we have to understand that cultural relativism, or the promoters or the representatives of cultural relativism, does not negate the potential existence of universal values, but they provide a line to examine the practical implementation of universality within a scientific framework. Yes, so what is the role of social sciences in human rights research? I think it just amends the philosophical and legal research because it can raise many important questions about human rights, and I think I will skip some of my slides and end with this list, which was raised by Damien Short. He's a professor at University of London. He thinks that there are key sociological questions of human rights. How have rights come into social beings? How are rights socially constructed? How and why do particular social actors and groups claim and access rights? How are rights affected? What role is played by social structures? To what extent are rights guaranteed or limited by the law? And how power relations affected the construction and functionality of rights? And whose interests do rights actually work to protect? So these are very important questions, and I just brought these questions to give you something to bring with you for your journey back to home and to think about the social being of human rights. Thank you.
Thank you very much, Martin. And now we have time for Q&A. Yeah, well, we already have a question from Maria online. So, Csaba, if you don't mind answering that first, then we'll pop over to the other possible questions.
Okay. You hear me? Okay. Yeah, I think it's a difficult question because on the one hand, it was this Canadian-EU trade agreement was really were the first when, so the European Parliament was very adamant of incorporating all sort of. I'm telling the others now because probably not aware of that. They were very incorporating also human rights standards in the treaty, and there's always often makes a lot of noises, but then nothing comes out of it. And here it was a lot of those requests incorporated, but there was still a fundamental opposition to it from a rapporteur in the UN Human Rights Council, and there were several critiques of it. One of them was that the dispute settlement mechanism that is in there is still kind of removes these from state courts. These guidelines for business and human rights, which I talked about, is not incorporated into it, and environmental standards are sort of watered down, which is important because, as I was discussing it yesterday in a smaller circle, Canada. We always think Canada is nice and green, they're all progressive. Canada is one of the worst polluters on the planet, in Canada, but also abroad, because of the mining industry. So that's actually means a lot of, it's a lot of hard national economic interest that is involved there with environmental standards. So my opinion of that is that I think it was certainly a progress towards from previous agreements that the EU has concluded, and I think it's a progress. I don't think that it's this kind of fundamental opposition to dispute settlement mechanisms in these treaties is something that we could take out of them simply. I don't think that this would be agreed, and it's not because Canada is not a state governed by the rule of law, or the EU is not governed by the rule of law. It is simply because of this asymmetry that you have, that one, you can change the laws in your interest. So, but I think there is definitely much more room, and these kind of treaties always kind of hard kind of economic interests will be considered. So the environmental standards, the EU cannot force environmental standards on Canada which Canada doesn't want to have, because it's a sovereign country. So I don't get all the arguments against this kind of fundamental position, because I think just otherwise they wouldn't have an agreement. But I agree that there's certainly much more room, for example, incorporating business and human rights or labor standards in there. I'm a bit skeptical though that with countries or other entities that are lagging behind Canada in many of those standards, we could enforce those against them, unless there is a very fundamental power imbalance between the EU and those countries, and it's worth for them because in return they get access to a huge market. So fundamentally, I still think it's the market that is ruling this, and I'm not sure how we can kind of evade that hard power that the EU has with one of the largest markets on the planet in these trade treaties. I don't know if I answered your question.
Yes, thank you very much.
Okay. What is your opinion? Can I ask? You said you write.
Sorry, can't hear you.
What is your opinion? Because you said you're writing a PhD about it.
Yeah, it's very complex because I have a section in my PhD where I'm making these high-level interviews with people holding different positions into the state level, companies, academia, etc., etc. And my opinion from the very start was, when you're concluding so comprehensive and complex agreement like this, you need to make observation of the public opinion before going and diving into this kind of mechanism, because it's going back on your head in a manner that people are protesting against it. And if you're having approach in which you're informing the public about this kind of things, you're having like wide consensus to discuss the things that are not so approachable, the things that are not so somehow tricky, etc., etc. And in that manner, people are not perceiving the dispute settlement mechanism what's like something that is harmful for them, but in a manner that is going to be productive for them in the future. Because in a manner when you're not open to discussing this kind of mechanism, you're making the public perception that investment state dispute settlement is in favor of the corporation, and it's not in favor of the citizens. It's not in favor in their labor rights. It's not in favor in protecting environmental standards, etc., etc. And now we have a limbo situation where the states in the European Union are not going further with the ratification of the agreement. And we have another paradox where we have states that didn't ratify the agreement, but are using the benefits from the agreement. Now, because CETA has a provisional application, so they have increased trade, they have increased benefits, etc., etc. But on the other hand, they're not ratifying the agreement. And on the third hand, you have situation where the CETA survival in the future can be put in question because it can have a provisional application till endless. You know, you need to have some way forward in a way to make applicable these things. And I really appreciate your approach because you're making the dispute settlement mechanism to be understandable for the public. Because in a manner how the parties in the agreement are approaching the dispute settlement mechanism is in a manner that is not understandable for the public. And when you're not making things understandable for the wider public, you have protests, you have opposition, and you don't have a functional ratified agreement in the practice.
Thanks so much, Maria. We've had a question here. Point of order, do you want to take questions one by one? Or? Yeah, okay.
Hi, again. Thanks for the first speaker. So your presentation was eloquent in a way that you brought the problems and some sort of a future narratives how way forward. So I'm really thrilled at least to have the consensus of this dimension. But despite the fact, don't you think that we really miss the moral compasses on this regard? Because when it comes to international law, no matter whether it's a national law based on sovereignty or the global law based on corporate consensus, which have like overlapping interests when it comes to implementations or the problem solving or the settlement dispute. What we really see, the out of the box, is all about human rights, the environmental rights and concerns. So from that aspect, I do believe, I think the moral component or consensus should be in place, which I don't find from your presentation. Thank you.
We'll go one by one, sorry.
Oh, okay.
So we don't get lost in there.
I was probably not coming across. I didn't make my position probably understandable. I wanted to kind of balance a bit of argument that's saying that kind of these companies are legitimate interest because that's how the capital goes in them. But I also think that there's fundamental injustices involved in the structural characteristics of this system. So as to the moral argument, I fully agree that this should be an important, and all these standards, it is important, I think, when you're shaping up, environmental, this new discourse, which was supposed to be the original topic, but we don't talk about it, the sort of, environmental justice in vis-a-vis future indigenous groups that have a different lifestyle and different expectations of what the land is for. That this we question that it's good if you have roads and you have electricity and maybe it's just one, and they have a claim to the land, they live the way they want there, and we just flood the whole place because whatever Embraer needs more energy. So I fully agree with this. I mean, my position on this is that, and that's what makes. So I don't think that interest could be argued out of this, economic or political interest. there's a very famous public international lawyer, Finland, from Koski-Niemi is called, and he has a book. It's called The Gentle Civilizer of Nations. And I think that's a very good term of public international law is. So we have, I'm an institutionalist in that sense. That is important we have these institutions. And if they're used because of interest, that is still strengthens the institutions. And there is a very slow, very, very slow change. In the human rights standards, we are much further away than we was like 50 years ago. And so there is still, and that's what makes me, so that kind of this moral argument is at the core. And we shouldn't get depressed because all these interests are counteracting that sort of straight progress. But it's still there are institutions, and we're building these institutions, and you have to think in environmental, in this progress in decades or centuries even, that it changes slowly, and helping, again, if you use institutions because of interest, they still strengthens institutions. So that would be my argument to the moral argument. I fully agree that it's a moral core to it. That should be. Because otherwise that is just free-for-all, definitely. Yeah.
Great. Alira, you had a...
I want to thank the panelists for the excellent presentations. And starting from the very first perspective on human rights, I think individuals are born with some natural rights, and then they can gain some more rights, but these basic rights, which are also universal rights, are related to freedom, property, and life, and then they were expanded in other categories like civic, political, cultural, economic, and social rights. But I think that a breakthrough moment when it comes to awareness for human rights was after the World War II. There we see some gaps that these societies, but also states, needed to do something for that huge human rights violation. And that is related to more awareness and more regulation when it comes to human rights, humanitarian law and criminal law. But the question is, when it comes to social facts, for example, how important is to bring awareness in countries that there is not such a developed political and civic culture? Because you need to bring that awareness that human rights are associated with responsibilities, with expectations. So if you do not have that awareness, if you do not have that civic education, so how do you see tangible social facts on that? So that is my question. And another question is related to the international law, for example. I see international law, norms, values are shifting because we have powerful states that are playing on that. And we don't know if we are going to have international institutions to safeguard these norms, this international law in the future. So maybe emancipated societies, modern societies, will demand on that and will bring it into the right path, because the international law was born out of the necessities to be based, so states to be based, to base their behaviors on some norms, some ethical values, morality. So maybe modern societies will demand on that. But how do you see the future right now of the international law? So these were my questions. Thank you.
Marty, you want to chime in?
Okay. Thank you, Elira. My answer for your question, I have uncertain answers, so I'm not sure if the idea of human rights can be imported into totally different cultural sets, but I do love the work of the late Sally Engle-Mary. I don't know if you know her. She was a legal anthropologist who coined the frame anthropology of human rights, and she argued that after the information revolution, so after the 80s, 90s, human rights gained such a global fame that they shaped our thinking globally. So they had an impact even in those cultural groups which do not have these cultural mindsets which comes with human rights. And she did research on these different dialogues. She has a great book called Gender Rights and Gender Violence, and she did research in southeastern Asia and the Pacific Ocean area, and she focused on the state of women's rights. And her research was really on a global scale, because she did research on UN level, she did research on national level, and she did research in small groups. And she had very fascinating findings about how, for example, some gender rights were implemented in a totally unique way in small groups, in small cultural groups, which did not have any linkage to this mostly Western idea of human rights. I will stop because we'll run out of time. But if you're interested, I have a very interesting story about how Hong Kong women organized themselves and tried to persuade back in the late 90s state agents to raise awareness of családon belüli erőszak, domestic violence. It's a fascinating book. I would send it to you. Of course, I downloaded it very legally.
Csaba, do you want to add anything to it, or?
Yeah, so I'm at this. I mean, I just want to try to show that in my presentation that great powers has always disregarded public international law if they fit the interest. So I don't think that what is happening. True, that's true, but I think I still look at like the Greek picture is like look at the war in Ukraine. So 100 years ago or 50 years ago, even us people on the street, or like go to Vas megye and ask people, like Matyas is doing. Do you think nations can't fight wars with each other? He said, oh, surely, that's how they do. And now, there is a much broader agreement that this is wrong and this is a crime. And that's due to public international law. And it's also international criminal law. I mean, no, I don't have any doubts that Putin will never stand in a dock in The Hague. But every time he wants to travel somewhere, you have to consider very carefully. There's a big fight about whether he should arrest him or not, should we allow him or not. That is also because of public international law. And that's a fundamental change. Even if he won't be arrested, that strengthens the institutions long term. So I think at this moment, I'm not thinking that they're speaking differently and they do it the worst way possible, probably, but I don't think that anything changed dramatically so far in that respect.
We have online participants who I want to give some preference to if I think they have some questions in the chat. If Gergő, maybe you can open up the no questions. Okay, I just okay then.
Thank you for the fascinating presentations, and they're really touching upon fundamental problems, unsolved, maybe unsolvable for the time being problems of our present turmoil and global chaos. Just want to remind you, maybe the younger generations don't have any memories about this. I don't know how much is taught in schools and in universities about the 70s when the human rights regime globally strengthened and evolved. And in 75, there was an agreement which the Soviet Union signed. That was the so-called third basket of the Helsinki Agreement. And then the Soviet Union gave up its doctrine that any kind of intervention coming from the press outside of the Soviet Union is acceptable, because up until that, the doctrine was that if Western press or anyone is criticizing the lack of human rights in the Soviet Union and the Soviet bloc, this is ignorable because it's kind of an intrusion, an aggressive act against the sovereignty of nations or a coalition of nations where the rule of the proletariat is the most important one, or defines law. And that was a turning point. Because after that, exactly, after it was signed, Charter 77 was born. And nobody could claim that it is something impossible, that the whole world was demanding that Václav Havel should be released from the prison, etc. So it reinforced what we call the freedom fight against the Soviet authoritarian regime. Now, what I want to say, it's all contextual. Now, we have the same paradox. What is the relationship between the sovereign, whoever calls it the sovereign state, or and the global? So this is the globalization of human rights helped us, oppositions and democratic forces in Eastern Central Europe, to fight for freedom. That was the context. But it was also dependent, and that's what I wanted to say, on the economic conditionality, and because the West, that then the existing West said, well, if you want trade with us, if you want financial help, etc., you have to keep yourself to this, you have to adjust yourself to the international agreement about human rights. So that was already an interdependence. So the moral, the political, and the economic. So, and this is what I suggest for us and for you, if you want to work with us, I would be very happy to think more about this problematic and apply it to the present situation. Okay, I don't want to go further because it's getting very long. Thank you.
Thank you. Do you guys want to respond to that, or
just a quick comment that thank you for your comment, and I do think so. I also think that studying the effects of the signing of the Helsinki Accord is very important. Moyne also wrote about it, but I think there is still work to do, because he, of course, focused on the U.S. situation and the Western situation, and he only cited, for example, from the Charter 77 co-signers, only cited, for example, Conrad, and left out many others. So I think it's worth a thorough research.
Amazing.
Okay, I'll start. Hello, I'm Flora, and I am Armenian from Nagorno-Karabakh. Connected to the human rights, the first which comes to my mind is that humans have rights to live. Humans have right to get nutrition and the basic stuff for their life. And what refers to it, from 2022 to 2023, there was a blockade, and Armenians in Nagorno-Karabakh, they could not receive a nutrition. They could not receive the elementary stuff for their living. it is not internationally recognized territory, but my question is that what should we do? Don't these people have the right? We were trying for 1 year to raise our voices, to ask help, but don't we have the rights if we are not internationally recognized? This is my question.
Yeah, of course we have those rights. And I think it's one of the cases where I think the EU is very selective in enforcing its human rights expectations. And we buy a lot of gas from Azerbaijan, so we just talk a bit and then buy the gas. So I think that is one of these examples they're talking about, that we are talking very nicely, but we're very selective in enforcing our own standards. And of course you have those rights. Yeah.
I totally agree. It's a shameful side of law.
Hello, my name is Lika. I'm from Georgia. First of all, thank you for your interesting presentations. They were really thought-provoking. So without further ado, here's my first question. Well, human rights belong to everyone and shouldn't be taken away, but some governments use cultural and sovereignty as an excuse to limit them. How can the world protect human rights without forcing one set of beliefs onto different nations? And my second question is, in an era of cyber globalization, how can international law combat digital colonialization while ensuring cybersecurity measures do not become the tools of oppression, especially in cases like Uyghurs, where mass surveillance and cyber control threaten cultural identity and fundamental rights? And for those who don't know this case, I can do like brief introduction. So the Uyghur case refers to the Muslim minority in China, Xinjiang. This case includes like mass surveillance, digital tracking, internet censorship, and AI-driven policing. Authorities use cyber tools to monitor Uyghurs' movements, restrict their cultural and religious expressions, and detain them in so-called re-education camps. Well, this case is an example of digital colonialization, where a state's use of technology controls and suppresses a group's identity and freedoms, raising major human rights concerns. Thank you.
Thanks.
Mine was the first question. You raised a very important question and problem of human rights. There's a very wide range of literature on that. It first emerged in the mainstream human rights study, I think during the 90s when the so-called Asian question arose. This question was about whether South Asian countries can sacrifice human rights on the altar of economic success, and they can do it with citing their cultural uniqueness or cultural differences. And it was very interesting what one British scholar, Anthony Woody, was found, that besides that these countries were not very friendly towards, for example, social and economic rights, so for example, labor rights, some little changes were taken into effect. For example, in Japan, where labor rights were in black letter law, but in practice they were like ineffective. They became slowly effective by transforming them and adapting them into their cultural context. So, for example, institutions like trade unions, which lack traditions, which lack the tradition in Japan, were non-existent. But because they derived in practice these rights from the benevolent, enforceable benevolence, which was a known phrase and known practice in Japan, they somehow transferred them into effective labor rights. Not very effective, but step by step a bit. And sometimes they are very, very unsuccessful. But I think the power of human rights lies in its strong versacular power. So the language of human rights is what gives it power. Vernacular, not that versacular, vernacular power.
Okay. So my one was a China case, right? That was for me. Again, that is one of these cases that China is doing this, and it's the biggest economy on the planet, and they just, or the second biggest, and everyone just accepts it and very aggressively communicating it. I've been to a conference last year. I was in Canada. Was where it was an academic workshop where China sent a diplomat. Someone talked about Uyghurs, and he stood up some guy and said he's the assistant third secretary of something in an embassy, and he will now read the Chinese government's position on this, that it is all not happening. So yeah, so I think it is the question that we can ask is that we, the European Union, we are essentially in the same league in terms of the size of the economy. So we could decide to act more in line with the human standards that we talk about that much. It will hurt us enormously, but we can also hurt China. You know, small states can't do that. We can do that, and we are not doing it. So there's a discussion to be had whether we should act more on put our feet where our mouth is and do it, but we don't.
Unfortunately, our time is up for this panel, and we've already done 2 hours. So, okay, yeah, if you can be brief then.
Yes. So, hello, I'm Saleh from Azerbaijan. So I would like to make a little comment because of the time limit to my colleague from Armenia, because of the blockade, what happened like the 2 years before, 2 or 3 years before. So I also made some research for now and also the years before. This territory has always been open for the humanitarian aids and humanitarian purpose. And why this territory has been closed? Just because of some powers has illegally transport the weapons, even how can I say, inside of the humanitarian cars. Therefore, even the Armenian side has also proved that this territory has always been open for how can I say, for the food, for humanitarian purpose. It's always been open. And what is more, even I made the research for now, the Red Crescent, which is the international organization, has also proved that. And this territory, if someone wants to have some, how can I say, the positive response, the Azerbaijan side has never been illegally declared this. Thank you.
Okay, thank you. Unfortunately, we don't have the time to dwell on that. Yes, I'm gonna. Yeah. So now is the lunch break until 2 o'clock, I think, so we have plenty of time to continue discussion. And afterwards, you're going to have a brief walking tour of Kőszeg, the brevity depending upon the weather. With Monica.
Thank you. Just very briefly, first of all, the weather is great, so we shouldn't complain. Hungary needed this rain very badly due to the climate change, so good news. And it's not so cold, so don't worry about that. Raincoat is, preferable if you have. But anyway, we shall meet here because of the rain, of course, I don't want to torture you. So I will give you a short, introduction into what we are going to see. We will visit several, sites in Kőszeg, in downtown. And so we meet here and then we go around, okay? So see you at 2. Thank you. And bon appetit.
Yeah, and lunch is at the same, yeah? Okay, thanks to the online participants as well, and thank you all for your comments and questions, and thanks to our panelists, Csaba, Győry, and Márton, Matyasovszky-Németh. Thank you.